Hey everyone, this is Alex Stryzak with my MPA 545 Week 6 presentation. So an overview of this presentation, we're going to look at 4 of the hybrids and judicial processes that we reviewed for this week, including early neutral evaluation, dispute review board, mini trial, and then summary jury trial. We'll look at an academic journal article on each one of these, and then a recent news article on one of these topics as well. So the first alternative dispute resolution that I'm going to look at is the early neutral evaluation, which is abbreviated ENE. And this is a conflict resolution approach that has a third-party neutral individual that has knowledge and background in the subject matter, and they're brought in to help with the negotiations. So both parties provide written statements and a description of what is necessary for the case. The ENE session is processed with each party then presenting their stance, and then the neutral party will assess the strengths and weaknesses and let them know, both parties, what might happen if this were to go to court. So the article that I looked at that involved early neutral evaluations was Applications to Custody and Parenting, Time Cases Program Development and Implementation in Hennepin County is what it's called in Minnesota. And actually this article explained how the ENE program reduced the stress and expense of custody for the clients, and it actually expedited the judicial case management process. And they had showed that child custody disputes and divorces were actually settled much quicker in early neutral evaluations and didn't go to court and did an out-of-court settlement where there was less stress through the whole process, and both sides ended up settling on an agreement that they found satisfactory. The second ADR we're looking at is Dispute Review Board, and this is a process that's made up of a panel of experts. So this panel is chosen by both the client and the contractor in the dispute, and after the board is established, they'll do these non-binding rulings on contract issues, and then they'll actually meet as a board quarterly to assess the development of the project and to make sure that all the contractual obligations are being fulfilled. So the article that I studied was by 4 different authors that were Nidikuri, can't say that, Peter Chapman, Nigel Smith, and Will Hughes, and what their article described was not only the best practices for appointing and finding a dispute board member, but also there was a part of training and how we present the information to the dispute board in the most neutral way possible. So it took into account and extended a little bit on the discussions of making sure that the board members that are brought in are experts in the field, but not too specific to one area. We don't want any biases when we're making these decisions, so it's important that they have an overall knowledge of the entire situation if they're going to be a board member. So the next ADR we're looking at is mini trials, and this is a non-binding structured type hearing, and it's mainly focuses on resolving things like antitrust, contracts, patent infringement, and then employee grievances is another one. And the goal is to get it done within 2 to 3 days. Now, this option is usually more expensive than other ones we've studied, like mediation and arbitration, but it's actually way less expensive than litigation. So basically, a well-respected attorney or retired judge is chosen. They'll be the nonpartisan selection to hear the case, and they make sure that everything that's presented in the case is relative, both in relevant, in witnesses and documents. So the article I looked at was the mini trial and alternative dispute resolution procedure by Edelman and Carr, and what it discussed was the U.S. Army, it was the U.S. Army Corps of Engineers, and it was about taking away the time and expenses of different contract claims and other complicated issues. And actually, they presented the option of having what was called a mini trial, where it was voluntary, everything was expedited, and it was a non-judicial process where top management officials of each party would meet to resolve the dispute before it got to court. And they were surprised in this article, they viewed it, how many people actually adapted to the mini trial, and that was their choice. And it turned out to be the best suit for the organizational needs as a whole. So the last ADR we're looking at is summary jury trial, which is abbreviated SJT, and it associates, it's a non-binding trial as well, but this is following the discovery phase of case preparation, and then it's before the case actually goes to a full trial. And the point of this is to eliminate the time-consuming tasks. It's a really abbreviated format where the parties beforehand file their memoranda and propose questions, and then each party does a 15-minute opening statement, 1 hour each to present, and then a half an hour of rebuttals. And there's a brief deliberation between the jury. They find a verdict that can help with post-settlement conferences. So the article I looked at was Reconfiguring the Summary Jury Trial from Metzloff, and it discussed that there were issues in the 90s about how people thought that SJT performance actually was arguably illegal, and how quickly it resolved the case, and that it was such an abbreviated tactic that important information was possibly left out. And so this article actually explored that the abbreviated format just put more pressure on each side to present the most important details that were the most relevant to the case, and actually some view it as more efficient and more likely to get a correct and more efficient and effective answer to solve the resolution, because some of they call the background noise has been cut out. So now looking at recent news articles that involve the alternative dispute resolution tactics, I looked at one that discussed about the review boards, dispute review boards involved mainly with construction. So the article was discussing whether dispute review boards should be admissible in court, so accepted in court or viewed evidence in the court of law. And the reason that this was important was there have been some cases that were presented in the article where a dispute review board's answer actually was viewed as invalid, but it was still in effect in that construction project. So if it's not valid in court, why is it valid that they are doing this construction process? And there are over 1,500 recommendations that are actually affecting over 1,200 construction projects in the U.S. from this article in 2012. So it was important. This article was trying to clarify we need to be all in or all out whether these dispute review boards' answers are seen as valid in court if they are brought up later in other construction projects when they're trying to get new projects going based off what has been successful or unsuccessful in the past. So in closing this presentation, looking at the different alternative dispute resolutions, all of these are based around the idea of trying to speed up the court process and what can sometimes drag on to be a difficult process for both parties where both feel like they did not get the answer that they needed or wanted. So there are different tactics of bringing in experts, but all of them are designed around the idea of trying to save both sides money and time to be as efficient as possible in resolving these conflicts.